Hi, welcome to EDSC 551 Legal and Ethical Issues. This is Professor Bobo, and it is week 4. During week 4, you have two discussion boards that are due this week. You should have an alert that will go off on Thursday. Make sure you complete both discussion boards as they are both due the week of during week 4. This week, I'll be discussing chapters 7 and 8 on child abuse and individual and group counseling and the ability to um, maintain confidentiality. During this, I'll go ahead and share with you a PowerPoint on those different topics. Let me go ahead and share my screen with you. All right. So, child abuse reporting for mandated reporters. As you are aware, all school counselors and many other employees on the school campus are mandated reporters. So, in this chapter, I'll be discussing the importance of child abuse and that we are required to be trained annually. Um, and who are those mandated reporters? Those are individuals required by law to report suspected child abuse or neglect. Once again, let us be reminded that we are only reporting suspected. It is not our responsibility to investigate. We are given information, and with that information, we make a report, and it is not our determination as to whether the report is followed through or carried out. Some of the mandated reporters include teachers, healthcare professionals, social workers, law enforcement, childcare providers, and they're mandated by state laws to ensure the safety and well-being of the children. So we have the 4 areas of abuse that we're taking a look at. We're looking at physical abuse, which is unexplained injuries, bruises, burns, or fractures. We're discussing looking for neglect or hygiene, malnutrition, and lack of supervision. We're also looking at emotional abuse, which is extreme behavioral changes, withdrawal, fearness. And then it's also sexual abuse, inappropriate knowledge of sexual behavior, or physical signs. So the legal obligation of the mandated reporters is that they must report reasonable suspicion of any child abuse or neglect, and reports must be made immediately or as soon as practicable. So reports need to be made within 24 hours of being given the information, and then a written report needs to follow within 36 hours. Failure to report can result in legal consequences, including fines and penalties, and reports are confidential and made in good faith to protect the child. Now, you cannot make a report as a mandated reporter confidentially. They will not even take your report if you refuse to give your name as a mandated reporter. It is important that you give your information, and the courts do their best to keep the reports confidential. One experience is that most of the time when your name is given, it is because it's given by the student to the parent. Once the student reveals who they told at the school about the information, it's pretty easy for the parent or guardian to discover who made the report. So this is something just to keep in mind of how your name gets out there. Rarely is the name reported directly who made the report. That could happen in court at the court level, but at that point, a lot more is probably going on. So it is important to identify the appropriate agency to contact. So for us, we call Department of Children and Family Services here in California. That's how we report. Other agencies are called Child Protective Services. So you may receive calls from other agencies outside where Child Protective Services and the family may be locating into California. So this is another agency. Or we may go to law enforcement. If there is physical abuse, usually law enforcement is contacted. We need to provide detailed information what I do as a school counselor, and some help for that, is that we need to make sure that we repeat questions many different ways and hopefully get the same response from the student. Also, it helps if they've told another person so that you can collaborate with both parties, both mandated reporters, in order to get the best possible information to place on the report. If two mandated reporters are given the information, only one person needs to make the report. And it just needs to be ensured that both parties are aware who made the report. A description of the suspected abuse, you write down exactly what the child stated. The child stated, student stated XYZ. I fell, or my mother pushed me into the closet door, and my eye hit the doorknob, which is why I have a black eye. Why did your mother push you? My mother pushed me because she was angry with me for playing around and I wouldn't stop. Um, any relevant context or evidence. If I see a mark, I do take a picture of the mark. Many of the social workers are requesting a picture of that. I upload the picture to the documentation that when I'm sending in my written report. And then that way, and I get permission from the student to take a picture of their injury. And I don't give a whole body. I just kind of take the area that is pertinent to the information so that they have an idea of what I visually saw on that specific day. And follow up with a written report, which is required by law. That's the 36-hour report. So you have 36 hours to submit your report to the online services. As you're well aware, our Department of Children and Family Services only does online reports at this time. So it's important for counselors to establish an account so that they can upload their reports and input their reports through the Department of Children and Family Services once they begin as a school counselor. And then cooperate with investigations as needed. Many times you'll get a follow-up through by phone, by email. Today, I get mostly emails from social workers verifying information and then requesting a phone call or requesting conversation in regards to that. Understanding that reports are made in good faith and are protected from civil and criminal liability. So if that's what the person said to you, you want to make sure that the student, you can have another adult there in the room so they can collaborate, or corroborate what the child said. Because if the child is making up something, you are only required to go by what, if you see a mark or you see something, they could have burned themselves, they could have fallen, and they're blaming it on the parent because they're angry with the parent, but that's not your responsibility. Your responsibility is only to state that, this is what the student said at that time, and then ensure that the mandated reporter can act without fear of retaliation. So making sure of that. So it's important for us as mandated reporters to, report. One of the things that's super important to the mandating reporting is two mandated reporters can hear the information, but oftentimes there are people on your campus that are afraid to make the report. If they are afraid to make the report, it is their responsibility to make the report, especially when it's secondhand information. So you can tell the individual that you would be willing to listen and hear the information as a school counselor, but it doesn't always um, the student may not tell you the exact information that they told their teacher. So it's important that if they change the information, that the original person make the report as needed. So this is something that many districts were using in the past. Making sure that the administrator or school counselor with more experience, all students were just sent to them, and that is inaccurate. Everyone is a mandated reporter, so even if you are brand new, a method that we use in my school district is I sit with that new person and take them through the process. so that they're able to understand the process and have that experience so that they don't get to 5 or 10 years and never having made a report or being aware of how to make a report. Timeliness and accurate reporting is essential for the effective intervention. Again, I have see bruises all the time on students, and I receive information from social services saying the case is closed. It is not my responsibility. Again, I only sent the picture as it related to the incident at that time. They may have investigated much further at home, gone to the home multiple times, and discovered that whatever the child said to me was not accurate. So it isn't that you look at an injury and assume that someone is doing the harm. It's their responsibility. What we want on record legally as a school counselor is to ensure that we made the report. So if in the future something happens to that particular child, your name is not brought into the case or you are not depositioned for that situation due to the fact that you didn't make the report. It will show that you were made, that the report was made, and that the remainder of that is on the responsibility of the investigating agency. And always prioritize the child's safety. In Chapter 8, we're talking about individual and small group counseling as it relates to confidentiality. So, group counseling, school counselors have a tremendous amount of responsibility in schools trying to deliver individual and group counseling. We see this as a tier 2 and tier 3 service for all students. So, an example is we give a tier 1 intervention to all students, and then in tier 2 and tier 3, we are giving it to individuals and small groups for those who need additional interventions in regards to whatever subject matter regarding mental health. So, individual and group counseling comes into play because we need to revisit some of those topics. There are many concerns with individual and group counseling where confidentiality can't be guaranteed, and sensitive information about the private world of students and their families is often discussed. So, confidentiality in groups is even more concerning in virtual groups. And as you know, those who share this, sharing the room or within an earshot, we can't control that, especially virtually. So groups reach more students and are essential methods for school counselors and other human service personnel. So it is essential that we hold individual and group counseling, but it's also very difficult for us to maintain confidentiality. So confidentiality is covered by standard A2 of the ethical standards, and it means that counselors provide informed consent, disclosing the terms at and or before entering this counseling relationship or at the beginning of the counseling sessions to provide counselees the purpose, the goal, the techniques, and the rules of procedures under which they may be receiving this counseling service. So this informed consent is given to the parents, and the parents sign off on this informed consent, discussing what the student will be reviewing in this counseling service, and whether the service is individual or group. The counselor tries to explain the meaning of confidentiality in developmentally appropriate terms to help the student understand. School counselors will try to keep confidences, except when the counselor determines serious or foreseeable harm is present. So that is serious and foreseeable is a shift from the previous idea of clear and imminent danger, which after several incidents was found to be insufficient to cover the situations which school counselors may know of danger that could not be classified as clear and imminent, but still needed to be addressed. Therefore, the term serious and foreseeable was adopted to provide a larger blanket of protection for school counselors and students as well. So again, our informed consent will go over the purposes, goals, techniques, rules, and procedures under which the individual is receiving counseling. Um, we need to know that the informed consent requires competence, voluntariness, and knowledge of the student's part to understand the limitations of confidentiality, and therefore could be difficult to obtain from students of certain developmental levels and special need populations. And that the school counselor should make attempts to gain a set appropriate to the individual student and prior to disclosure. That we need to be aware that even though attempts are made to obtain informed consent, it's not always possible. And the school counselor needs to make decisions on students' behalf that promote students' welfare. So sometimes we can put a student in a counseling session and we can try to inform the parents. But if they are not, we also need to maybe make that decision to place them in a small group for a certain amount of time in order to promote the students' health and welfare. And just explain that the limits of confidentiality in developmentally appropriate terms through multiple methods, such as student handbooks, classroom lessons, verbal notification to individual students, and school counseling department website, brochures, and social media accounts. There are three reasons in which we would break confidentiality. And these are the three that I always say it this way. If someone is hurting you, if you plan to hurt someone else, or you plan to hurt yourself. So these are the things that we tell them that we're not able to keep that information confidential and that we would have to contact the appropriate personnel, agencies, organizations that as it applies to whichever one the student is obtaining to. All right, so those are the highlights of our two chapters for this week. And again, you have two discussion boards due this week. Thank you so much and have a good evening.